Hi everyone! So let's continue to Title 7 on stocks and stockholders. Medyo mahaba, it's a bit of a long provision, so bear with me. Okay. Now, when it comes to Section 59, I would like to highlight that it is a contract for the acquisition of unissued stock. Okay, not issued stock. So I will not discuss anymore, but I just want to mention that subscription is different from purchase because the subscription can be made even before the incorporation of a corporation, while a purchase a purchase of regular shares can only be done after an incorporation. This is because a subscription contract is actually unique. It's not really strictly compliant with the law of contracts. If you remember, a contract is an agreement between two or more entities, persons or entities. And in this case, the subscription contract is entered into by a subscriber and a corporation that's not yet in existence. I think that's the reason why Section 59 had to be made. The rights of a shareholder accrue only upon his entry in the books of the corporation, in the stock and transfer book. That is the regular course of business. Now, because of Section 59 under a subscription contract, then the rights of a subscriber prior to the incorporation of a corporation is now recognized. So these subscribers, meaning those who acquire unissued stock before incorporation, or what we call original subscribers, they become holders from the time of the issuance of the certificate of incorporation by the SEC. This is true even if the corporate secretary failed to reflect the fact of their subscription in the stock and transfer book. Hi everyone! Let's now talk about Title 7, so stocks and stockholders. Let's start with subscription contract. It's right in front of you. I would just like to highlight the word unissued. So subscription contracts only referred to unissued stocks. Now, it is different from a purchase because a purchase can be made only after incorporation. When I say purchase of stocks, So, in a subscription contract, can be entered into before or after incorporation. If there is no agreement as to the time of payment in a subscription agreement, they need not pay unless there is a call, and we will discuss that when we get to the later provisions. Whereas in a sale, they must fully pay the purchase price at the time the shares are transferred to them. The subscriber cannot be released from his obligation to pay the subscription price, whereas a stockholder who sells his or her shares to another one can condone the obligation of the purchaser to pay. Condone means to forgive or to forgo. So those are the differences between a subscription and a regular purchase. As a rule, only persons whose ownerships are registered in the stock and transfer book are considered shareholders of record. The rights of a stockholder accrue only upon entry of his name in the books of a corporation. That's why there are already Supreme Court cases that states that mere inclusion of the person's name in the general information sheet is insufficient proof of ownership. But with respect to original subscribers, meaning those who enter into subscription contracts before the incorporation, are shareholders from the time of the issuance of the certificate of incorporation by the SEC. So technically, there is a different treatment when it comes to original subscribers. If this is true, meaning original subscribers are shareholders, even if the corporate secretary fails to reflect that fact in the stock and transfer book. So usually, one of their ways to prove ownership is by showing their names as appearing in the articles of incorporation. So the perfection of a subscription contract usually starts when an offer is made and the offer is accepted. If you remember if I remember in obligations, there is in contracts, there's an obligation, there is a contract when there is an offer and it is accepted, diba? I just want to share that because there was a case between Trilliana versus Quezon College where the company offered shares, the school offered shares to a certain individual who did not accept the offer made but made a counter offer. Eventually, that individual died. What happened was the college still wanted to collect money from the estate of the deceased. And the Supreme Court said there was no subscription contract because the college never accepted the counter offer. How do you acquire ownership in subscription? There is no formality necessary to perfect the subscription contract. So it's usually just the delivery of the subscription contract. Yan. So there is a difference between stock options and subscription contracts. I just want to say it in passing. Stock options are privileges granted to a party to subscribe to a certain portion of an issued capital stock within a specified period and under certain terms and conditions. So a stock option is a privilege. It's not an actual stock. A warrant, on the other hand, is a type of security that entitles the holder the right to subscribe to an issued capital stock evidenced by a warrant certificate. And that warrant certificate is maybe sold separately from the right to subscribe, or it can be prohibited from being sold separately. I will not anymore discuss the types of warrants because I don't think it's important for board accountancy majors for your exams. Although if you'd want to learn about it, I'm not sure if it's included in the CPA board. I'm not sure. And I'm sure you discussed this in your later accounting subjects. Subscription warrants entitle the holder to subscribe to a predetermined amount of shares out of the unissued capital stock. A covered warrant entitles one to purchase predetermined number of shares of already issued stocks. So that's subscription warrants on one hand and covered warrants on the other. Let's see. A underlying shares means the unissued shares of a corporation that may be purchased by the warrant holder upon the exercise of the right granted under it. Beneficiary securities means the shares of stock and other securities of the issuer which form the basis of the entitlement in a warrant. So, the reason why there is Section 59 is because a subscription contract is not strictly compliant with the law on contracts. If you remember, a contract is an agreement between two or more persons or entities. So in a subscription contract, the parties are really the subscriber and the corporation itself. But note, if the subscription contract is for original subscribers, there is no corporation to speak of yet because they are in the process of incorporating pa lang. So while a subscription contract is really an agreement between the subscriber and the corporation and not a contract between the subscribers amongst themselves, in a sense, although not strictly speaking, the subscription contract is also a contract among the subscribers because the original subscriber cannot withdraw from the pre-incorporation subscription agreement without the consent of all shareholders. And that will be here under Section 60. And there. So this is different between an agreement between two individuals or two entities to enter into a joint venture agreement. That's okay. That is not what is contemplated under Section 60. How about trustees and nominees? A trustee may even be a nominee who holds the shares of another, but one is usually named under them, so that that nominee can be qualified as a director. So a nominee is a person in whose name a stock certificate is registered but who is not the actual owner thereof. So they are like representatives. So a subscription contract may cover one or more shares. The subscription contract is indivisible, and I will repeat this again, but I'll start now. It is indivisible in a sense that if a subscription contract covers 100 shares, and say I only paid 70 shares of my 100 shares in the contract, I cannot go to the corporation and say, please issue me certificates of stock worth for 70 shares. Here's my subscription contract, and give me another subscription contract for the 30. It cannot. It's indivisible. So later on in the later provisions, you will see that issuance of the certificate of stock can only be made upon full payment. There is no law or rule in the Philippines requiring a form of subscription to capital stock as a prerequisite to its validity. So it actually need not be in writing. It may be verbally. If a person accepts certificate of stock in his name or exercises the rights of shareholders, he is liable to the unpaid subscription even if there is no express contract. Now, you'd be wondering, Miss, why were you already mentioning contracts as if there's paper? Because it's normal business practice to issue it. Syempre, it's for the protection of the stockholder. I mean, let's be practical. If you were to invest in a corporation, would you actually pay money for some of it and then not have any form of written proof, di ba? You usually want a subscription contract. But I'm just saying, if you're going to be extremely strict about it, it can be a verbal contract for subscription. Part of the discussion when it comes to stocks is the trust fund doctrine. I think I mentioned that in previous videos. A corporation, when you talk about a trust fund doctrine, a corporation may not dissipate funds or stocks, capital stocks, subscribed capital stocks also, and the creditors may sue stockholders directly for their unpaid subscription. The creditors need not wait for the corporation to file a case on their behalf. They can do so because of the trust fund doctrine. So just take note, although you will, for those of you who are reading a book or cases or notes of previous classes, the trust fund doctrine usually appears when we talk about subscription contracts. The point there being that once there is a subscription contract, the corporation cannot, for example, in my case, diba, if you remember, I said, okay, I entered into a contract for 100 shares and I only paid 70 shares. The corporation cannot say, okay, Miss Cruz, you don't need to pay for the 30 shares anymore, we'll let it go. Just because we're generous. That cannot be, because that will violate the trust fund doctrine. Precisely because the subscribed shares are for the protection of creditors. So the creditors can sue me directly for the 30 unpaid shares, say in case of insolvency. But even if you hear the trust fund doctrine when it comes to unsubscribed shares, the trust fund doctrine covers all, not just the unpaid portion, the capital stock, property, and assets of the corporation. They are part of it. Take note, this is tricky. Money received for subscription of increase of authorized capital is not covered by the trust fund doctrine prior to the approval of such increase by the SEC. If you remember my previous discussion when it comes to increase of authorized capital stock, any payments made therein prior to the approval by the SEC is technically a deposit. So the corporation holds that money in trust for the stockholders where everyone is waiting for the condition being the SEC's approval for the increase of capital stock. Additional paid in capital, APIC, is also part of the trust fund doctrine, so it cannot be declared as dividend, and neither can it be reclassified to absorb deficiency. except through an organizational restructuring. So there are cases here I just want to mention very quickly where the trust fund doctrine was violated when the corporation condones payment of unsubscribed capital, unpaid subscription, which I just gave an example on. When there is payment of dividends without unrestricted retained earnings, because if you pay dividends without unrestricted retained earnings, you are technically paying stockholders capital. You're returning their capital in effect because there's no excess. When properties are transferred in front of creditors, when properties are disposed or undue preference is given to some creditors, even if the corporation is insolvent, when capital stock is decreased, which has the effect of relieving the stockholders of the obligation to pay their respective subscriptions. So it's more like number 1. Now, although I just mentioned instances where distribution of capital is violative of the trust fund doctrine, not all distributions of capital violate that doctrine. What are the instances when it does not violate? 3 are mentioned in the book I'm reading. 1, the amendment of the articles to reduce authorized capital stock. So eventually, if all the capital stock were already paid for, then to reduce it and it is approved by the SEC, it's a return on capital that is not violative of the trust fund doctrine. Number 2, purchase of redeemable shares, regardless of the existence of unrestricted or retained earnings, because it's under the code. And 3, dissolution and eventual liquidation of the corporation, precisely because when you liquidate, who do you prioritize? Creditors. Alright. Treasury shares are not subject to subscription contracts, and that's why earlier I emphasized on the word unissued, because treasury shares cannot be subject of subscription contracts. However, despite that, if treasury shares are reissued, the shareholders are entitled to exercise their preemptive right. If you remember when we talked about preemptive right, the preemptive right is given to shareholders, in generally speaking, in order for shareholders to maintain their percentage of interest in the corporation. How about escrow shares, meaning shares that are held by an escrow while they are waiting for the fulfillment of a condition? The subscriber is not yet the owner of those escrow shares, so they cannot be given the rights belonging to a stockholder until the condition is fulfilled. Sorry, I'm on the left side of the picture. Just note that the issuance of shares out of unsubscribed shares of authorized capital stock does not need stockholders' approval. It's obvious. But in practice, what is necessary is a board resolution approving for that. Section 60, pre-incorporation subscription. It is irrevocable for a period of 6 months from the date of subscription unless all consent to the revocation. It is irrevocable unless the corporation fails to incorporate within the same period of 6 months or within a longer period stipulated in the contract of subscription. And in any case, it cannot be revoked after the articles is submitted to the commission. So it's relatively self-explanatory. Section 61, consideration for stocks. The stock shall not be issued for a consideration less than the par or issued price thereof. So it contemplates watered stocks and bonus stocks. I'll discuss what bonus stocks are later. Just take note of that. So consideration for the issuance of stocks may be A to, H. So here is A to G and H. Oh, before I forget, when you talk about letter E, amounts transferred from unrestricted retained earnings to stated capital, these are normally declaration. Beautiful handwriting. of stock dividends. There. Letter F, outstanding. Another type of consideration is outstanding shares exchanged for stocks, meaning parang trading, in the event of reclassification, meaning you change preferred to common, or the other way around, or conversion. When you talk about conversion, we are talking about, this includes conversion of a single proprietorship or partnership into a corporation, or a spin-off of one or more divisions of the company. The consideration in these cases, meaning if partnership is converted into a corporation, is actually the net assets of the partnership. Shares of stock in another corporation can be a valid consideration. Take note, if shares of stock of a corporation, say we're talking about Corporation A, are issued in exchange for another corporation, another shares of stock of another corporation, then it should be subject to Section 41. Remember the power to invest in another corporation if it is not the primary business. Where the consideration is other than actual cash, it must be evaluated, which shall initially be determined by the stockholders or the board, always upon the approval of the commission. Why? This is to avoid watered stocks, meaning you issue stocks, say, worth 1 million pesos, but the property given to you is just worth 800,000. Now, take note of the prohibition. Shares of stock shall not be issued in exchange for promissory notes or future service. It can be, though, for past service, say a lawyer who renders service for the corporation. Instead of the corporation paying the lawyer money, they will pay shares, or to employees. That's perfectly valid. And these types of considerations under letter A to H may also be used for the issuance of bonds. Bonds are liabilities, no, of the corporation. And I'm sure you know this under your accounting subject, so I don't need to mention that anyway. So the issued price of no par value, so here it talks about no par value, may be fixed 3 ways in the articles, by the board, if the articles delegate that authority to the board, or the bylaws. So if it's not fixed, it can be fixed by a majority vote of the outstanding capital stock. So I don't remember if I placed this in the word note. If you remember in just the previous video, please note. I'm not sure if I typed it. I think I did. So when you talk about consideration under Section 61, the consideration here is not the same as consideration under the law on law on contracts. If you remember contracts, diba? Law on. If you remember under contracts, there must be cause, consent in the parties, right? And consideration, because under Section 61, consideration when it comes to stocks are just limited to the ones you see here on your screen. An additional requirement is when it comes to inward remittances for stocks with respect to corporations with foreign subscribers, there must be a bank certificate issued by the BSP if the foreign subscribers want to register their investments with the BSP. Now, what if a prospective stockholder will be giving tangible or intangible property? The property must be necessary or convenient for the corporation's use or for its lawful purposes. For example, a mining claim may be given as consideration. However, it must be necessary or convenient or used by the acquiring corporation. If you give a mining claim, usually it needs to have a mining permit as well. Otherwise, the corporation cannot engage in mining activities. So, surrender of the mining claim itself is not sufficient as payment for stocks. What about in undivided interest in real property? Can that be made can that be a consideration for stocks? The answer is yes, subject to certain conditions. I will not mention that anymore. So I mentioned earlier, past services can be used as payment, say labor performed, like what I mentioned, additional compensation for employees or bonuses, yan, pwede yan. However, future services are not allowed. What is an example of future service? Movie star contracts, di ba? Contract signing. Why? Because when they sign the contract, the movie or the series or episode, whatever, has not yet been made. What does it mean? The actor has not performed, has not acted yet. So that's an example of future service. Previously incurred indebtedness of a corporation may be used as a consideration because they don't need to pay anymore. The indebtedness involved is one that is acknowledged by the board. So it's like the creditor of the corporation paid cash. It's similar to that. I hope I make sense. Please do message if I don't. A corporation, because of this exclusive list under A to H, a corporation cannot agree that the subscription price shall be paid only through dividends that will be declared later. In effect, what will happen is that the subscriber pays for nothing. The subscription is free. This is illegal and in fraud of other subscribers who actually paid money. What about deposits on subscription? Deposits meaning money received by the corporation with a possibility pa lang, not certainty, of applying the same as payment for the future issuance of capital stock. It is not subject to documentary stamp tax. The person making the deposit does not have the standing of a stockholder because there is no stocks issued yet. I think that's common sense. So they're not entitled to dividends. Section 62. Certificate of stock and transfer of shares. So the form of a certificate of stock is stated here in front of you. It shall be signed by the president or the vice president, countersigned by the secretary or assistant secretary, and sealed. And shall be issued in accordance with the bylaws. So it is personal property. Why does it need to be stated it's personal property? Because it may be transferred by delivery. As this is different from real property, which must be in writing, which must be registered for the effectivity of third persons, ganyan. It's different. So, in this case, no transfer, this is specifically under the law, no transfer shall be valid to other people. It is valid between the parties. That's why it says here, no transfer shall be valid except as between parties until it is recorded in the books. So, the last paragraph that you see there, no shares of stock against which the corporation holds any unpaid claim shall be transferable in the books. What do you mean when you say unpaid claims? These are arising from unpaid subscription, and not to any indebtedness which a subscriber may owe the corporation arising from other transactions. I just want to mention a street certificate. What is a street certificate? It is a stock certificate endorsed in blank by the owner. The holder is entitled to demand its transfer into his name from the issuing corporation. The exception to the right of a holder to demand transfer to his or her name is if the street certificate is stolen. Why? Because if it is stolen, there is really no delivery. Remember, it may be transferred by delivery. So who is allowed to transfer the shares? The answer is the true owner, the owner. So in a case between a trustor and a trustee, it is the trustor, the one who is the true owner. It is he or she who can dispose of the shares without any interference from the trustee. A transfer that is not allowed, if you remember our law on partnerships, is between spouses. These transfers of stock from one spouse to another is void if and only if they are governed by the system of absolute community property regime. Those are for marriages after August 3, if I'm not mistaken, 1987. Why? Because in an absolute community property regime, the spouses agree that at the time that they marry, what's mine is yours, what's yours is mine. If you know that adage. What if there is no certificate? Obviously, there can be no delivery because what needs to be delivered? The certificate. It's right there in front of you. I just want to emphasize that. Might appear in the exam. A corporation is not bound and cannot be required to issue a new certificate unless the original is produced and surrendered. The surrender and cancellation of the old certificate serve to protect not only the corporation but the legitimate stockholder and public as well. We don't want different types of certificates floating around for the same shares of stock. So what are the reasons why there is a registration requirement? So that the transferee can exercise all the rights of the stockholder. There is an opportunity for the corporation to object or refuse any claim against the stock, to inform the corporation of the change of ownership, and to avoid any fictitious transfers. So third persons are not affected if the transfer is not registered. For example, a creditor decides to attach the rights in the shares of A, but little did the creditor know that A actually transferred or surrendered his share to B. B cannot say that the creditor has no right because B did not yet go to the corporation, surrender the stocks, and have his transfer registered in the books. So the registration requirement under section 62 here, the recording or registration only refers to transfers. What do you mean when we say transfer? It means the original owner divests or removes ownership and gives it to another. So ownership is acquired by another. Meaning, if it is mortgaged, the shares are mortgaged by chattel mortgage, it need not be registered. Anyway, it's registered with the registry of deeds, Also, if there is an attachment, as I mentioned earlier, the creditor need not register that in the books of the corporation because, an attachment and a mortgage does not make the creditor or the mortgagee the owner of the shares. They just hold it as security. Since we mentioned transfers already, there is no prohibition to transfer the subscription agreement itself. What do I mean? For example, in my case, if you remember, I subscribed to 100 shares, I paid for 70, I have 30. I can transfer the entire 100 shares to Mr. X. What would that mean? Mr. X now will be liable to pay for the 30 shares. In that case, there will be a novation. If you remember your law on obligations, how to extinguish obligations is through novation, where the debtor is substituted from an old debtor me to a new debtor, Mr. X. So there was a case where I just want to share this. The Supreme Court case I read. The corporation, I'll make myself as an example in the Supreme Court case. I subscribed to 100 shares. I only paid 50%. What happened was that the corporation mistakenly issued me certificates of stock for 100. I now go holding the stocks and give it to Mr. X. And I sell it to the entire 100 shares to him. Now, Mr. X is not entitled to um the question was, who does the corporation run after? This was also asked in the 1981 bar. The answer is it's Mr. X who needs to pay, because if you look at it, it's Mr. The certificates of stock are with him. He's the one liable. So it would make you think it's unfair for Mr. X because he already paid me 100% of the price, while I only paid 50%. The question there is, whom does the corporation or the creditors of the corporation run after for the unpaid subscription? It's Mr. X. But Mr. X is not left holding the bag. Mr. X can always run after me in a separate action. How about a transfer through succession? Meaning I pass away, not soon I hope. What about my heirs? Will they be stockholders automatically? If you look at it, under the law on succession, the heirs actually become owners at the time of the death, except stocks. The stocks the transfer must be recorded in the books kasi it's under the law. And if you remember, it's actually the administrator or the executor duly appointed by the court who can exercise the powers of a stockholder. If I haven't mentioned that in the previous video, I will mention that later. I read kasi ahead. So the corporation may actually regulate the transfer of the shares in such a way that they may give particular rules on how transfers can be effected for convenience and expediency. Yeah. But the regulation cannot go so much that the stockholder is now limited in terms of his or her right to transfer the shares. Meaning, the corporation cannot say, no, we're just regulating the transfer. If you look at the rules of the corporation, they are effectively restricting or prohibiting the stockholder from transferring shares to another, because that is a right of a stockholder to transfer. So a corporation may not stamp on the certificates that they are non-transferable, following the same logic of what I just mentioned. Even if the corporation cannot restrict a stockholder from transferring the stockholder's rights to someone else, a stockholder nevertheless may still enter into an agreement with a third person to restrict the transfer of his or her shares. Why is that allowed? Because that's already an agreement between the stockholder and someone else. What we are prohibiting is the corporation from restricting the stockholder's rights. So what if there is already a transfer and the transferee already has the stocks, surrenders it, and requests for registration in the books, but the officer or the corporate secretary refuses? The transferee can now compel them by going to court and filing a case for mandamus, because it is a ministerial duty of the corporate secretary. What do I mean when I say ministerial duty? For those who want to take up law, it means it's a duty where that corporate secretary does not have the discretion to decide. They can't judge na, I don't want to because I think the stock is, I think you really didn't pay for it. No, that's not, that's what I mean by ministerial. They don't have the right to decide if they will actually perform their duty or not. As long as the transferee complies with the requirements of surrender, and syempre the stocks are endorsed to the transferee, then the corporate secretary must issue shares in the name of the new stockholder. So, aside from delivery, I will stress again, the stocks must be endorsed to him or endorsed in blank. There's a case asked in the 2001 bar. A is the owner of shares. A now made an endorsement on the stock certificate and handed it to his best friend B to hold it for safekeeping. Actually, no, B borrowed the stocks to support his application for passport. Because if, for those of you who have not applied for your passport on your own, usually there's a need to show that you can afford to travel. Yeah. Now, B, without A's knowledge, actually sold the shares to X. X is a purchaser in good faith. He doesn't know that the stocks were just entrusted to be for a particular purpose. Can A claim the shares of stock from X? The answer is no. Because A is stopped from questioning the transfer because A already endorsed the certificate of stock. So A knows that whoever holds it, especially if the endorsement is blank, will be presumed the owner thereof. This would be a different answer if B stole the certificate of stock from A. In that case, kasi the one I mentioned earlier, A actually delivered the stock certificates to B. So just before I end on this section 62, the certificate is not stock in the corporation. It's merely evidence of a holder's interest and status in the corporation. Okay? It's not equivalent to ownership. Alright. Section 63. Issuance of stock certificates. Again, by the principle of indivisibility, the certificates shall not be issued until the full payment together with interest and expense in case of delinquent shares, if any issue has been paid. So a stock certificate expresses the contract, but it is not essential in the existence of the share. Okay? As I mentioned just now, it's just evidence of ownership. So, possession of the stock certificate actually is not the sole determining factor of one's stock ownership, say, especially for pre-incorporation subscriptions. There's the articles of incorporation that can prove it, the stock and transfer book, or official receipts of payment of the subscription, or a secretary's certificate, the general information sheet at times, or the minutes of the meetings. So those can be pieces of evidence to prove ownership of shares, not just having or possessing the stock certificates. So, because of the particular requirement of stock certificates as mentioned under section 62 here, the form there, a mere typewritten statement advising a stockholder of the extent of his ownership is not a stock certificate. If you look at section 63, it says here, no certificate shall be issued to a subscriber. What's the importance of the word to a subscriber? A stock certificate must be issued to a named subscriber, although it is quasi-negotiable in a sense that it can be endorsed in blank. The initial issuance must be to a named stockholder and not to bearer or to holder. The authority to issue shares of stock under section 63 is not unconditional. The condition is there must be an issued authorized capital stock. If the authorized capital stock has been completely issued, then it cannot issue anymore. And neither the corporation nor the person to whom the stock is issued can invoke estoppel when, for example, let me give an example. If, for example, the authorized capital stock is 100 shares, and the corporation already issued 100 shares worth of stock certificates, later on, the corporation issued an additional 5. So it already issued stock certificates worth 105. Can the owner of the extra 5 certificates of stock claim that they are stockholders and say, no, the corporation is stopped or they are prohibited from questioning my ownership because they gave it to me? The answer is no. Because the issuance of stocks must be under the assumption that they're actually issuance. They're actually unissued shares pa. Okay. Remember I mentioned that a subscription contract can be transferred to someone else. Like in my case, I have 100 shares, 30 remain unpaid. I transfer it to Mr. X. That was just mentioned mga 5 minutes ago. In that case, because it is innovation under the law on obligations and contracts, if you remember, because it's innovation under Article 1293 of the Civil Code, there must be consent by the creditor. In this case, the corporation. Because the what is changed is the debtor. Because also of the indivisibility of a subscription contract, sorry I keep jumping from one topic to another, but anyway, 61, 62, and 63, section 61, 62, and 63 are connected somehow. In my case, I have 70 paid and 30 unpaid. I cannot assign the 30 unpaid shares to another person because that would be violating the principle of indivisibility. So what is the remedy of a shareholder if the corporation refuses to issue a certificate? 1. File an action with the court for specific performance. 2. File an action for damages if specific performance cannot be made. 3. Petition for mandamus, meaning to compel the issuance. And 4. Rescission. So I will not talk about that anymore because it's for law students. How about a forged or a spurious certificate? It is void. Especially, say, forged certificates can be those where there is no signature of the president or vice president. It is not signed also by the secretary or the assistant secretary, or there's no seal. And these, again, I will repeat, as I've mentioned earlier, these cannot be honored even if it's in the hands of a buyer in good faith. Okay. How about section 64, liability of directors for watered stocks? Here, these are the types of watered stocks, and the liability is solidary for the difference of the value of the stocks and the value received. So again, these are different from bonus stocks, which I mentioned earlier, and I promised I will define. Bonus stocks are stocks that are issued without any valuable consideration. Watered stocks are issued for less. So there is consideration, just less. Bonus stocks, talagang bonus. No consideration whatsoever. They're also covered by the prohibition under Section 61. So why are watered stocks not allowed? Because it is like a condonation for the unpaid subscription. It's similar to that. Because the subscriber is not required to pay for the full price. Okay, what about unpaid subscription? Under Section 65, there is interest, and it shall be from the date of the subscription. And it is at the rate fixed in the contract. If there's no rate, then the legal rate. And right now, under BSP Monetary Board Circular from July 1, 2013 until present, legal interest is just 6%. Yeah. Why is there interest already from the date of subscription? Because upon the agreement to enter into a subscription, the subscriber is a stockholder and is entitled to all the rights. It would be unfair for the stockholder just to pay for the amount without any interest, but the stockholder can actually receive dividends already if it's declared by the corporation, diba? And that's usually why there's interest. Section 66 talks about the payment of the balance. So here, the board of directors may at any time declare due and demandable the unpaid subscriptions and may collect the same or such percentage thereof, in either case with accrued interest as it may deem necessary. So, payment of the unpaid or any percentage shall be made on the date specified in the subscription contract. If it's not specified in the contract, then that's where you look at the time that the date that the call was made by the board. What if they fail to pay? even just a portion. Remember, it says here at the paragraph, it can be by just a percentage. Failure to pay will render the entire balance due and payable, and there will be legal interest at the rate of such balance. If you remember, just in section 65 above, there is interest on the unpaid subscriptions automatically from the date of the subscription. What does it mean? The interest here, yeah, is on top of the interest there. This is not compounding interest, ha. This is just simple interest on the interest. So if there is no payment made within 30 days from the date, then all stocks covered by the subscription become delinquent. So in my case, again, if I paid for 70 and I have 30 shares unpaid, then I am delinquent for the entire 100 shares. But the board may always provide otherwise. So the reason for this is because stock subscriptions are considered a debt of a shareholder to the corporation. So a call is a resolution or formal declaration of the board that the unpaid subscriptions are due and demandable. It can be for the payment of total or just a portion, or it can be on installment. Yan. But the call of the board presupposes that there is no agreement at the time of the subscription contract. So, meaning, if there is already a date specified in the contract, the board cannot disregard that. That would be a violation of its contract with the subscriber. A call must be made on all. It cannot be on some. That's discriminatory because if it were only on some, it cannot be, a call cannot be made if the subscribers would be required to pay a higher rate. Diba? Because it must be at the rate stated in the contract. Or it must not be oppressive. So, under the law, under the civil code, there are no such things as usurious interest. Before kasi there's a certain percentage cap that it's already invalid. Now, the courts will decide what is unfair. Normally, usually the legal interest is usually up to 2% a month it's allowed. So a call is not necessary again when the date is specified in the subscription. In another instance, when the call is not necessary, although it's not stated in section 66, is when the corporation becomes insolvent. So, when insolvency supervenes upon a corporation and the court assumes jurisdiction to wind up, all unpaid subscriptions become payable on demand and are at once recoverable in an action instituted by the assignee or the receiver. Meaning the receiver is the one who will take care of the affairs of the corporation upon insolvency proceedings. Yeah, so those are the two instances when a call is not necessary. So there is no set-off. Although the corporation is a creditor and the subscriber is a debtor, if there is no call yet or it's not yet due, then there can be no set-off or compensation. Compensation kasi, sorry ha, for those, since you're not law students, if you do decide to become lawyers, compensation can mean two things. Compensation salary, sweldo, payment, or compensation meaning set off. I owe you, you owe me, call it quits. Yan. So that's another term for compensation. So because there is no set off, a corporation cannot deduct an employee salary for the employee's unpaid subscription of shares. Because remember, employees naman can be shareholders too. The corporation cannot withhold cash dividends from the subscribers who have not fully paid their subscriptions unless they are delinquent or the stockholders allow that the cash dividends be used as payment for the unpaid subscription. Neither can the corporation get the stock dividends as payment for the unpaid subscription because there really is no debtor-creditor relationship man with respect to shares ha. And also, if the corporation decides to get the stock dividends as payment, it would in effect be reacquiring its own shares, which is not allowed under Section 40 of the Revised Corporation Code. Because Section 40, if you remember, we mentioned it enumerates instances and conditions wherein a corporation may legally purchase and acquire its own shares. When you talk about delinquency here under Section 66, it is automatic. There is no more need for another action. What do you mean when you say unless the board of directors orders otherwise? It only means that the board may order the removal of the delinquent status of unpaid corporation. Here's an example in a case of Apocada versus NLRC. Victor was employed by MAIA Corporation. He subscribed to 1,500 shares of the corporation. He made an initial down payment of 37,500 out of the 150,000 pesos. And then he was appointed president and general manager. Because of his disagreement with the board, he resigned and demanded payment of his unpaid salary, his cost of living allowance, his bonus, and reimbursement of his gasoline and representation expenses. Now, although MAIA Corporation admitted that it owed Victor 40,000, they told him that they will not pay him because he still had an unpaid subscription of 100,000. There was no call or notice for the payment of the unpaid subscription. So now Victor questioned the set-off or the compensation. There is there cannot be any set-off because a call is necessary. What if there was a call? Can set-off be applied? The answer is still no, because Victor is entitled to salaries. They have no right to withhold in the salary in payment for the unpaid subscription. This is also because it's violative of labor laws. Okay, now Section 67, when it comes to delinquency sale, it's quite long. So just read that. The importance is the board of directors must order the sale by resolution. Because it's a corporate act. And there is a time limit here. The time and date of sale shall not be less than 30 or more than 60 days from the time that the stocks become delinquent. The notice must be sent with a copy of the resolution. It's already there in front of you. There must be publication. Unless there is another manner of disposing of these delinquent shares, it's by a public auction. This is what you need to look into. Usually, this is what's asked in the board exams. When you talk about the bidder, a bidder is the one who will pay for the entire full amount of the balance for the smallest number of shares or a fraction of the share. Now, why is this important? For example, if as an example, if 100, in my case, diba, I have not yet paid 30 shares of my 100 shares subscribed, and say for easy computation, those 30 shares are worth 30,000 pesos, then it will be sold at a public auction for the full amount of the 30,000 with interest. Now, for example, everything is 35,000 and it will be at a public auction. What will happen is that if there are two bidders, one will pay 35,000 for 20 shares and the other will pay 30,000 for 25 shares. Then the highest bidder is the one who is willing to pay for the whole 35,000 for 20 shares only. What will happen is that the remaining 10 shares of the 30 will be credited to me. Yeah. So I will be entitled to the issuance of a stock certificate covering the shares. You might be asking, wait, miss, you just said that the subscription contract is indivisible. Why is there some division right now? Because this is already a delinquency sale. In other words, it's sort of like I breached my obligation under the subscription contract. The subscription contract will be disregarded already because under the law, there's a new set of rules when it comes to my being delinquent. Now, there's this division. I get the 70 plus the 10. Remember, the bidder in my example allowed to pay for the full prices for 20. Yan. What if there is no bidder who offers to pay the full amount? Either there's no bidder at all, or no one wants to pay for the full 35,000. Then the corporation may bid for the same, and the total amount due shall be credited as fully paid in the books of the corporation. Title to all the shares of stock covered by the subscription shall be vested in the corporation as treasury shares. So in that example, if there's no bidding, the corporation will get the entire 30. So when I'll discuss this with 68, when may the sales be questioned? No action to recover delinquency stock sold can be sustained just because there was an irregularity or defect in the notice or in the sale itself, unless I first pay or tender to the party holding the stock. When you say party holding the stock, you're talking about the winning bidder. So in my case, if I still want to question it because it's irregular, then I can go to the smallest bidder, the one who paid 35,000, and pay it to him with interest from the date of sale at 6% because legal rate. Yan. But I cannot file any action with the court if I file it after 6 months. There's a prescriptive period, 6 months from the date of the sale. So this talks about court actions. So in any case, even if there can be a delinquency sale, auction, or whatnot, and I can question it in court, under Section 69, the corporation can always collect the amount that I owe. So even if the court now has the option to call the unpaid subscription, resort to a delinquency sale, those options under Section 66, 67, and 68 does not prohibit the corporation to simply go to court and file a case for specific performance or collection of a sum of money. So, just note that in my example, I'm the delinquent stockholder, and the corporation complies with the publication, the notice, and everything, and the dates prescribed a 30 to 60 day period within which the corporation can hold a public auction. I can always stop the delinquency sale if I pay the corporation on or before the date specified for the sale of the delinquency stock. The payment automatically stops the sale, but the sale may always be stayed by the board. If you remember, says there na unless the board declares otherwise. So it's not naman illegal for the board to stop it itself. The Section 66, 67, 68 are just remedies available to the corporation. These are not required. Now, what if, for example, I go there to the sale, I make drama, and I say, stop the sale. Itigil ang, sorry, I can't speak Tagalog because there are some here who don't understand Filipino, it's fine. What happens then? I give a check and I say, itigil ang bidding, here's my payment. Will that be allowed? The answer is no, because check is not legal tender. It must be cash. So that's our legal tender. So bitcoins are not allowed as payment also. Although I do understand that they are valuable. Because under the law, legal payment is cash. What if, for example, my delinquent stocks are to be sold on today, what's midnight? January 26. What if I went yesterday, January 20? What if I went last week, January 20? And I paid the check. Is it valid? Yes, upon encashment of the check. So I must prove that the check was already encashed. Because by the time of encashment, syempre, it's already legal tender. Encashment nga diba? It becomes cash. Section 70, effect of delinquency. No delinquent stock shall be voted or entitled to vote. Just read it there. Except they have the right to dividends. Okay. So, the delinquent stockholder cannot be elected as director mainly because they cannot vote and be voted, and they cannot continue serving as directors. Only until full payment that they will be restored of their full rights. So, this is why, as I earlier mentioned when we were talking about meetings, they are not included when we are computing or determining quorum. So, because the delinquent stockholders cannot vote, they cannot also assign the right to vote. Because what you cannot do directly, you cannot do indirectly. What are the rights of unpaid shares for non-delinquent? They have all the rights. This is just to distinguish 70 and 71. So what is the right of a non-delinquent subscriber that is withheld from them? The right to have a stock certificate issued to them. That's the only right that is not allowed to a non-delinquent subscriber. So what are the basic rights of a shareholder for your reference? Can I just dictate them because I don't want to type them down? There are 12. Right to vote under Section 6. Right to remove directors under 27. Right to dividends under 42. Appraisal right under 80. Right to issuance of stock certificate for fully paid shares under 63. Proportionate participation in the distribution of assets in liquidation, Section 139. Right to transfer stocks in corporate books, 62. Preemptive right under 38. Right to inspect books and records under 73. Right to be furnished the most recent financial statement or financial report, 74. We'll discuss it in a bit. Right to recover stocks unlawfully sold for delinquent payment of subscription, 68. And right to file individual suit, representative suit, and derivative suit. What are the obligations of a stockholder? There are 5 here. Liability to the corporation for unpaid subscription. We just discussed that, 66 to 69. Liability for interest on the unpaid subscription if it is in the contract, under Section 65. Liability to creditors for unpaid subscription under the limited liability rule and also under the trust fund doctrine. Liability for watered stock, 64, and liability for dividends unlawfully paid, Section 42. So now if you notice, I mentioned individual suit, the right to file an individual suit, representative suit, and derivative suit. What are these? An individual suit, obviously, I file a case on my behalf. Representative suit, I file a case on my behalf and on my own behalf and on behalf of other stockholders. And derivative actions. Derivative actions are actually meant to protect usually minority stockholders' interests, and it's usually to redress wrongs committed against the corporation, mostly by the board of directors. So it's really a suit on behalf of the corporation. So when you talk about derivative actions, it's also in Attorney Laco's notes, no? The word derivative actions. I'll just expand a little bit on it. The requirement to file a derivative action is for a person to be a stockholder at the time of the questioned transaction and also at the time of filing the complaint. So a transferee who was not yet a stockholder at the time of the transaction cannot initiate the action on behalf of the corporation. The exception would be if that transaction continues to injure this stockholder. Then the stockholder can file a derivative action. So again, I will repeat, stockholder usually sues for mismanagement, waste, or dissipation of corporate assets because it usually causes a special injury to him, no? And this is a final recourse, meaning if other modes can be availed of to correct this mismanagement or questionable transaction, then those other remedies must be resorted to first. Okay. Lost or destroyed certificates. It's right in front of you. So what needs to be done? The procedure is under letter A and letter B. Let me just go. Sorry. There. So first, an affidavit in triplicate. You have to narrate how you lost it. And then it must be verified under letter B in front of you on the screen. And there must be publication in the newspaper. And the contents are stated there in the notice. And then if no contest was presented, or then the right to contest or question the issuance of a new certificate will be barred. The corporation shall cancel the lost, destroyed, or stolen certificate in its books, and in lieu thereof, it shall issue a new certificate of stock unless the registered owner files a bond or security effective for 1 year for such amount, so that the new certificate may be issued even before the 1 year period that is stated there. Okay. In case of fraud, bad faith, or negligence on the part of the corporation and its officers, no action may be brought against a corporation which shall have issued the certificate of stock in lieu of these lost ones, as long as they follow the procedure under A and B. Why are there so many requirements? This is for the protection of the owner, because it's possible that someone pretends that the stock is lost so that a new one will be issued to this con artist, sabihin natin, for to be able to distinguish. So that that con artist who pretended that the stocks were lost can get a new one under his name, and that con artist can now exercise all the powers of a stockholder. Because it says here under this section, let me just show you the title, lost or destroyed, it does not apply to worn out certificates. It's in cases of worn out certificates, the corporation now will have to decide if it wants to replace them. Therefore, for worn out, torn certificates, yung konti lang not destroyed, then the corporation need not follow the procedure under 72. So the provision under 72 is not applicable if the certificate was never issued in the first place. Okay? And section 72 also does not apply if the certificate was lost by the corporation. Why? Because how can the stockholder issue an affidavit on how it was lost if it was not the stockholder who lost it, but the corporation? So, this is what's so beautiful about the law, and the reason why I took up because law is logic. It's based on experience and common sense. Now, if you're like me who does not have common sense, you can still be a lawyer. Okay. The requirements under Section 72 are mandatory in nature. Although they are mandatory, substantial compliance is also allowed in certain instances. Okay, so that's it for Title 7, and I will see you in Title 8.